Can you hear us?
Yes, I can hear you. Can you hear me okay? Can you hear me, Deputy Everett?
They can hear you just fine, Judge.
Yes, I can hear you. Okay. Yes. Can you hear me, Deputy Everett? Another 2 years will still have problems. All right, I think I got that worked out. All right, Mr. Weiner, are you here on Mr. Prox from Mr. Head?
Yes, Your Honor, I am. We're ready.
All right, Mr. Prox, CR 15475, State versus Corey Prox, motion to revoke.
Yes, Your Honor. I've spoken with State briefly about this. We were retained about 5 days ago. I actually found out about this setting yesterday. So I did not get a chance to file a motion for continuance because I was filing an order for Judge Davis out of 369th in Cherokee County yesterday afternoon. So I don't have a copy of the motion to revoke. And obviously, I'm not ready to go forward today. And so I'd like some time to gather that information. I also will be filing a motion to set bail. And so I don't know if the court would like to set this for a contested setting date next, or how the court would like to handle that. But I just want to make the court aware I should be filing that today or tomorrow.
What we can do is we can set it for a status on the motion to revoke in December, and then we can also set it for a contested hearing on January 26th if there's no agreement had between now and then. So I can set on December 1st, 13th, or 15th.
Let me check my calendar. I appreciate the options, Judge. You said the 4th. I'm sorry, the 1st, the 4th.
No, 1st, 13th, or 15th.
Let's set it for the 13th. But I'm number 1 in Cherokee County on the 12th for a jury trial. So if it's okay, I'll keep the state and the court apprised of that status for that jury trial. Is that okay?
Yeah, that's fine. So what we'll do is today we'll go ahead and set it for the contested hearing on the 26th. So if you're not here on the 13th, then we'll just move to the contested hearing on January 26th.
Okay, and I'll reach out to the state and see if we can come up with an agreement. And if so, I'll submit it to the court.
Sounds good.
All right, go ahead and sign. It looks like I'm being jury trial. Come and see and let you know. Okay. Okay. All right, I'm tendering notice to my client. That's all I have. My excuse, Judge.
Yes, thank you, Mr. Weiner.
Good seeing you. I'll take a picture. But you're very nice.
His motion.
Oh yeah, I love that. You're still lying.
I mean, that's
Yes, thank you so much.
Mr. Schmidt, are you ready?
Sir, I'm ready on a plea for Jamie Nash.
All right, Jamie Nash. And can you go ahead and tell me what the terms of the plea are, Mr. Schmidt?
Judge, in this particular case, we're actually waiving indictment, pleading to an information on possession of controlled substance, 1 to 4 grams, third-degree felony. The terms are that upon a plea of guilt, punishment assessed to 4 years deferred community supervision, $1,500 fine. State's agreeing to waive the DPS restitution fee, as well as agreeing to take cause number CR 22-00338 into consideration under 1245 Texas Penal Code. The fine is $1,500, $290 in court costs, and then $515 reimbursements.
And you said the state's waiving the restitution for the lab?
That's correct.
All right, Mr. Nash, if you will, raise your right hand. I'm going to place you under oath. I'm sorry, Ms. Nash, if you'll raise your other hand. All right, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
All right, you put your hand down. Make sure you speak up loudly and clearly for me, okay? I've got a court reporter here with me. We need to take down everything that you say, okay?
Yes, sir.
All right, thank you. All right. Your name is Jamie Nash, correct?
Yes, sir.
And are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
And where you have signed in the paperwork, you've signed there only after you were confident that you understood what you were signing. Is that correct? And that's your true and correct signature in the paperwork?
Yes, sir.
All right, Mr. Schmidt, do you believe your client to be competent?
I do, Judge.
And you've explained all of the rights with regards to this case?
I have.
All right, I see that the charge in this case, well, actually, let's talk about the waiver of indictment in this case. Do you understand that you have the right to have your case presented to the grand jury and for the grand jury to determine whether or not they believe that there's enough evidence to hold you over for prosecution? Do you understand that?
Yes, sir.
And in fact, no one in the state of Texas can be prosecuted for a felony offense unless there's an indictment returned in their case, except for the situations where the defendant waives the right to the presentment of the case to the grand jury. Do you understand that?
Yes, sir.
And do you understand that by allowing the state to move forward on an information, you would be waiving the right to have that grand jury review your case?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to make you feel like you had to waive your right to waive the grand jury?
No, sir.
All right, the court will approve the waiver of right to indictment. Court will find that the state is proceeding on an information for the charge of possession of a controlled substance in penalty group 1 less or between 1 grams and 4 grams, a third-degree felony. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a fine of not more than $10,000. That means that any sentence, even by way of plea agreement in this case, must fit within that minimum 2 to that maximum 10. Do you understand that?
Sir.
Means you can't have more than 10 years in prison and you can't have less than 2. I see here that Mr. Schmidt has read the plea agreement, and the plea agreement is that your punishment be assessed at 4 years confinement in prison, along with fines and court costs and restitution.
Judge, it's actually 4 years deferred.
Oh, I'm sorry, 4 years deferred. All right, so let me back up. So the range of punishment is minimum 2 to a maximum of 10, and the court, if it approves this plea agreement today, would defer a finding of guilt, which would mean that the court would not convict you today. The court would place you on community supervision. And if while you are on community supervision, if you violate any of the terms and conditions of your community supervision, the state could bring you back to court and prove to the court through a motion that you have violated the terms and conditions of your community supervision. If they do that, then the court could convict you, the court could revoke your community supervision, and the court could assess your punishment for this crime anywhere from that minimum 2 years to the maximum 10 years in prison. Do you understand that full range of punishment and the process of probation?
Yes, sir.
All right, and so that would be for a period of 4 years, and you would also have to pay fines, court costs, and reimbursement fees. Understanding the range of punishment, understanding the deferred adjudication plea agreement, do you still wish to go forward in this case?
Yes, sir.
All right, then how do you plead to possession of a controlled substance? And you said, Mr. Schmidt, that is 1 to 4, correct?
That's correct, Judge.
Okay.
Guilty.
So how do you plead to possession of a controlled substance in Plea Group 1 greater than or equal to 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Sir.
Has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty to this crime today?
Sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objections to the evidence?
Objection.
All right, there being no objection, then the state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, briefly, just that the conditions of probation do include intensive supervision. I believe that's reflected in the conditions of probation. I don't believe it's reflected in judgment, but that is a condition of Ms. Nash's probation. That was actually suggested by Mr. Schmidt. And I think that that is well in her best interest.
And Mr. Schmidt, the condition of intensive supervision, is that included in the paperwork there?
Yeah, I believe it's in the conditions. Yeah. Hmm. Nash. I don't believe it's in there. I don't even think to look at that. It's not in there, Judge. We're gonna need to get a clean set of conditions that includes that, but she's aware of it. Understand that?
Yes, sir.
All right, anything further from the defense, Mr. Schmidt?
Yes, Judge. I'd like to briefly call Ms. Nash.
That's good.
I believe she's already been.
She has.
Ms. Nash, in this case, you understand that a grand jury did not request the indictment, but we're pleading to an information by agreement with the state. Understand that, right?
Yes, sir.
You also understand that the state's agreed to waive the DPS lab fee, and the reason why they agreed to waive that lab fee is a lab has not been returned on the controlled substances that were seized in your case. You understand that?
Yes, sir.
And you understand that I warned you about the pros and cons of moving forward without that lab return.
Yes, sir.
And I've told you that there have been cases where individuals were arrested for drugs and it turned out not to be.
Yes,
Did I
sir.
say that?
Yes, sir.
Okay, you understand that?
Yes,
And
sir.
knowing all that, do you have any doubt that it is in your best interest in the circumstances to proceed without that lab? And you pled guilty, so you would basically inform the court that the substance was indeed a controlled substance.
Yes, sir.
Thank you. I'll pass the witness.
Any questions from the state?
No, Your Honor.
All right, and Mr. Woodward, can you give me the facts to support the plea?
Yes, Your Honor. On August 4th, Van PD receives a multiple 911 calls that a female is walking down the middle of the road in Van, Texas. Officer with Van PD makes contact. It's Miss Jamie Nash. Upon asking who she was and if she's all right, she advised that she is all right, but she has something illegal on her person. Officer asks what it is. She reaches into her bra and pulls out a syringe. The officer asks her if it's methamphetamine, to which Miss Nash states, yes, it is. The officer field weighs the narcotics to 2.42 grams. I do believe that includes the syringe. The Texas Department of Public Safety lab does not test without specific request for that because it is in a syringe. That's why it was not tested. We believe we could test it, but obviously that would take some time. With Ms. Nash being in jail, we've decided to proceed as we have to this point.
All right. All right. Based on the evidence presented to the court will find that there is sufficient evidence to convict Jamie Nash of this offense. The court will follow the plea agreement reached between the defendant and the state. Court hereby convicts Jamie Nash of possession of a controlled substance, 3rd-degree felony. Penalty group 1, greater than or equal to 1 gram, less than 4 grams. Court, I'm sorry. I've written all this down wrong. I'm sorry. Ms. Nash, the court finds that there is sufficient evidence to convict you. However, the court will follow the plea agreement and the court will defer a finding of guilt in your case. The court will place you on 4 years of deferred community supervision. The court will order you to pay a $1,500 fine, $290 court cost, $515 reimbursement fees. Court will dismiss under section 1245, cause number CR 22. And did you say it was 328, Mr. Schmidt?
338, Judge.
Well, that's this case, right?
Not in the plea agreement. This is I've got CR 22-366. And then in the plea agreement, it's CR 22-338. Obviously, that sounds backwards.
Did she already have an indicted case?
Yes, sir. Yeah.
And what was that? What was that for?
It's a state jail PCS case, Your Honor.
And so this is the newer case. So this would be CR 22-366, you said?
I would think it's 366. That's correct. And we're actually 1245 and CR 22-338.
But on the top of the judgment, does it say 338 or 366?
366.
366. All right, the court dismisses under section 1245, cause number CR 22-338. Ms. Nash,
That's correct, Your Honor.
you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Go over with the deputy to be fingerprinted, and then probation officers will tell you information about the next step.
Judge, I think the confusion there is because we just filed the newer case. Mr. Schmidt asked the older case to be placed on the docket, and that's probably where we got off.
All right, Mr. Schmidt, who do you have?
Dustin Hall.
All right, this is cause number CR 21-385, State versus Dustin Lee Hall. Motion to revoke.
Correct, Judge. We have an agreement on Mr. Hall, and my hopes and dreams are to get that carried out today. Basically, we've agreed with the state to withdraw and continue and basically eat up Mr. Hall's credit time as a condition of community supervision. I don't know that we'll get the paperwork in time. It was a late agreement. So, I mean, if we want to recall him to the end, I can check with Mr. Woodwike and see if that's going to be possible, or maybe Ms. Heisel can tell us. If not, we could reset him to perhaps Thursday.
Yes, let's recall and we'll see how that goes. Try to get it done if we can.
Chill. Austin Hensley.
It was on the page with Nash.
All right, Austin Keith Hensley, CR 22-274. Show that we're pre-trial.
Yeah, we're set for pretrial. We don't have any contested. We've reached an agreement with the state. It has to be set for a plea sooner rather than later.
Is it for probation or time?
It's for probation and safety, Judge.
We could set it on Mr. Abraham, we really don't want to set anything on the 22nd if we've got a family law hearing at 10:30 anyway.
We can do it on Thursday if the state could be ready. Normally I wouldn't be here, but if you want to do that, we can, or we could just do it later in the month.
State, we can probably get it done in 2 days. It's at the courts and Mr. Schmidt's convenience. We can get it done.
All right, court will set Mr. Hensley then to enter his plea on Thursday of this week. And that will be at 1:30 on the 10th.
Mr. Schmidt, are we taking the probation with safety?
Yes, sir. You have
Say that name again.
Matthew England.
All right, Matthew Virgil England, CR 21-356.
That's correct, Judge. I think we're here on an MTR. I was appointed 4 or 5 days ago on Mr. England. It appears to me as though the motion alleges some new offenses, which are also pending in this county. I'd like to reset this and see if we can't get a package deal from Mr. England.
All right, court will set Mr. England on the contested docket on January 26th. And if there's an agreement between now and then, you can let the court know. We can set it for a plea.
I have Ryan Collier.
What do you say, Colin?
Collier.
Keith Collier, CR 22-126-127, set for pretrial.
That's correct, Judge. Judge, the last time we recorded, seems like it was less than a month ago. The state had provided some outstanding evidence. I'm in the process of going through that. It's digital evidence. And I believe that if the court would entertain it, I'll need one more pretrial setting. I do know that there will be pretrial motions that are likely to be contested, but I want to make sure that we get them all done in one shot. So if I could have that one more pretrial setting date, and get those motions on file.
How much time do you think you would need to get the remainder of the evidence so you can follow your motions?
Judge, I'm almost through with it, so I'm pretty close. Just a few days, really, if I can dedicate some more time to it sometime in the next week or so.
We can set either December 1 or 13 or 15.
How about December 13, Judge?
Okay. All right, court sets Mr. Collier then for pretrial 12/13 at 1:30.
That's all we have in here right now, other than Mr. Hall, that we'll recall, I guess, once we figure out whether we get the paperwork done.
Okay,
Judge, we're working on that paperwork right now. I'm confident we'll be able to get it done in the next little bit.
Sweet.
The jail's in the process of pulling the others.
okay, sounds good. Hey, Deputy Everett,
Yes, sir.
on Mr. Manning's clients, I believe we just appointed some to Mr. Manning today. I don't see the need in pulling them up if we can communicate to them that the court, I'll tell you what, don't worry about it. Let's bring them up. Let's bring them up and I'll let them know that I've appointed Mr. Manning and I'll give them a date. That way they know what's going on. I was thinking that might make it easier, but they may be concerned about who their attorney is and when their next court date is. So that's.
So, you know which ones those are, and I can reset forms.
Yes, Christopher Laney. Laney. Amber Martin. Next page, Andrew Skinner. Those would be Mr. Manning's clients.
All right, I'll get their resets done.
Thank you, sir. I do appreciate it.
Okay. So, Judge, we have Andrew Skinner when you're ready.
Okay, just one moment.
He's about to give a recent on date. Something. I'll put the note. Okay.
All right, Mr. Skinner, this is cause number CR 18507. Mr. Skinner, the court has reviewed your application for court-appointed attorney. Court finds you to be indigent for the purposes of having an attorney. Court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning is not scheduled to be in court today, so that his contact information will be sent to you, and I'm going to reset you today. And our next hearing will be on Thursday, December 15th. And we'll send notice to Mr. Manning, and I'm sure he'll be in contact with you before that date. And and Deputy Everett, this is on motion to revoke. All right, that's all, Mr. Skinner. Thank you.
Okay, thank you.
Everybody on now, Mr. Schmidt.
Cody White.
Cody D. White, CR 21346, motion to revoke.
That's correct, Judge. I was appointed today to represent Mr. White. I briefly looked at the motion. Obviously need a reset on this case.
All right, court will set Mr. White for the hearing on the motion on December 13th at 1:30. And the court will also set him for the contested hearing on January 26th if there's no resolution on that date.
Judge, we have Mr. Laney.
Yes, Mr. Laney. Christopher Glenn Laney, CR 21298.
Yes,
Mr. Laney, the court has reviewed your paperwork, finds that you are indigent. The court has appointed the Honorable Jonathan Manning to represent you. Just like I told Mr. Skinner, Mr. Manning is not scheduled to be in court today, so I'm going to make sure that you get the paperwork with his contact information. I'm going to notify him of our next setting, which is going to be December 15th. And he will be in contact with you before that date.
Right.
Okay, and that'll be at 1:30. Thank you, sir.
See if you can put it.
Barely. In places. I usually test. Step back.
Judge, I have Miss Amber Martin.
All right, Ms. Martin, the court has, this is CR 2179. The court has reviewed your application for court-appointed attorney, finds that you are indigent. Court has appointed Jonathan Manning to represent you. Mr. Manning is not scheduled to be in court today, so we're going to reset your hearing until December 15th. And Mr. Manning will be in contact with you before that date, and we'll make sure that you get a copy of the paperwork with his information so you can contact him as well, okay?
Okay.
And we'll be back on 12/15. It's a Thursday at 1:30.
Just come back. Just let people know.
So you're not looking for. Stay positive.
Feel better?
Are they bringing? Same. I guess so. Okay.
See the one that had this test.
Oh, yeah.
Yes, that issue.
Okay. Looks like.
Oh.
Is he black or is he one of? Oh, he's one of, you know.
He's the one in the green suit.
Motivation. That's a pretty common. Yeah, I find something more creative. Yeah. Hey, jail very happy. I'll add to it. Oh. You know. Yeah. It is if it keeps you out of here. Oh, shit. Oh. Yeah. Continue, so that about you now. Calculations. Woman, the job age twice as fast as you. I can get you the scientific journal further. It's there. My scientific journal. Are you ready? Sir. Yeah, we're wearing the white. Meek. Calm. Battle. Judge, we have a few ready if you are.
Who are you ready on?
We can do Mr. Hall first if you like.
All right, Mr. Hall. CR 21-385.
Correct. 00385 actually.
Let me correct that record. CR 21-00385 from Ms. Christian. Go ahead, Mr. Smith.
Exactly. Judge, we have a motion to withdraw and continue presented by the state. Basically, we've also got amended conditions, which adds my fee as well as Mr. Hall is to serve 40 days as a condition of community supervision reflected in the amendments.
You said 40 days,
Yes, sir.
and that's all with credit.
Yes, sir.
And how much is it 500?
Yes, sir.
All right, Mr. Hall, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir, I do.
All right, you can lower your hand. All right, so you've heard Mr. Schmidt say that the state in your agreement will withdraw their motion to adjudicate your guilt and place you back on community supervision. And as a condition of your community supervision, you're going to have to do 40 days in jail, with which you'll get credit for the 40 days that you've already served. And your conditions will be amended to include not only those 40 days as a condition of probation, but also an additional $500 for the motion to adjudicate that's been filed in this case. Is that what you're agreeing to today?
Yes, sir.
And you understand that if you receive another motion and you're revoked and you're sentenced to prison or jail, that you will not receive credit for these 40 days that you've done in jail?
Yes, sir, I do.
Okay. And has anybody forced you, threatened you, pressured you to enter into this agreement today?
No, sir.
Okay, all right, then the court will grant the state's motion to withdraw the warrant. The court will amend the community supervision conditions of Dustin Lee Hall to include 40 days in jail as a condition of community supervision with credit for time served. The court will also order Mr. Hall to pay a reimbursement fee of $500 to Van Zandt County for legal indigent fees.
Thank you, Judge.
You're welcome.
Yeah, man. Good luck to you. Toshia or Toshi? Oh, no. You're talking, yeah, that's probably right. That's all right. Tasha Bells.
All right, Tasha Marie Bells. I believe the jail has her listed as Hobson. Which one is it, Miss Hobson Bells? Bells? It's Bells, okay. Well, that's what I've got, but I think the jail calls you Hobson for some reason. All right, this is CR 21-00319. And I think it's motion to revoke.
It is, Judge, and I was appointed this afternoon to represent Ms. Bells. We're not ready. So we'd ask this be set. If the court wants to set on that next contested docket, that'd be fine. Hopefully motivate us to get it resolved.
The next contested would be. We don't have a contested this month. Actually, we do. We do have a contested this month. That's the 22nd. Is that the one you want?
Yes, sir.
Okay. All right. Court will set Miss Bells then for contested hearing on 11/29. It's actually 3 weeks.
You say 11/29 or 22?
29. I do have a docket on the 22nd, but the contested docket is the 29th. I misspoke on that.
Okay, thank you.
29.
Thank you.
Amanda Mead.
Amanda Robin Meek, CR 20-00218.
And Judge, that's an MTR as well. You could have that same date. That 11/29 date.
All right, court will set Miss Meek for hearing on November 29th at 1:30.
Broad date.
And it looks like we'll be in the JP2 courtroom, Mr. Schmidt.
Thank you. Is the court going to transport inmates on that date?
Yes, for contested hearings, I will make arrangements to have inmates in person.
Thank you. Now we just like Mr. Minister.
I have to call you.
No, that's what's important. I mean, see, that's the difference. Between criminal, right? Yeah, well, dang.
Oh.
It's white cars. Yay.
Deputy Everett, we haven't called Amber Martin yet, have we? We may have, and I may have,
Yes, we did.
we did, okay, I just didn't mark that one off. We said 12:15.
For a motion to revoke.
See the one we're waiting on a better Terrell. Not this file, but maybe.
Let's have-
So we have Robert Gerard and Matthew Peters. And Mr. Ashmore, I think, is going to be on ZOOM.
He didn't do the paperwork.
I think his client was out on trustee or something when he came by to talk to him. So he didn't have that opportunity.
All right.
So I think those are the only ones we have left, Gerard and Peters.
Yeah.
She's been all this is her talking. What is that? She's like, they're saying I'm not going to jail today.
Well, yeah.
I was like, they're not having nothing.
Not today.
I mean, she was like, just not, she's. Like she turned. She's the one who on her last NCR, they're like, oh my God, if we got it again, we're gonna send you to prison and max you out.
And they meant it when they said it. That's why I can think big book. Talk them down from that.
And you must have something on, just whatever Richard says is what we do.
They're all afraid of them. GA and be the boss. That's.
And you'd be like, I know how.
I'd vote for you.
I would vote for you.
Probably don't even vote.
I do, thank you very much. Actually, not early though, that's your weekend.
I'm the same way. I'd rather just get done.
But they
you
moved
figure
it to the library.
Library.
It used to be over there like. Old water damage.
I think the library worked out pretty good. It's just a parking situation. And we only had 3 wrecks. You know, those.
They were not.
I got it. I figured. That's what happens when the Zoom is running. You never know who's listening. And I was not saying anything that I wanted you to do. No, back in the first time. The camera was, see straight down to the clerk's desk. Anyway, it wasn't just me, it was your guys who said it too. Both of them. But it was able to- that's the problem. Yeah, well, never know, you want to judge.
Judge, I think we're ready when you are.
All right, court call CR 2267, State versus Robert Gerard.
Gerard.
Gerard, pretrial.
Thank you. Judge, at this point, we're gonna ask to set it on a doc call. We've got experts on the line to get some things set up with Mr. Gerard. In addition to that, there's gonna be some conversations that need to be had pertaining to additional experts between the state, myself, and perhaps the court at a later date. But at this point, we'd ask for a doc call announcement.
All right, court will set Mr. Gerard for docket call. You want that December 13th date? Do you need it to be later, sooner?
December 13th, fine.
All right, court sets Mr. Gerard then for docket call on December 13th. That'd be at 1:30.
Here, hold up. Robert.
Only about 15 minutes, it was talking about- I don't know about utility. He's, yeah, some figures. What you're gonna be by Zoom?
No, I had another one, another deal down here. I heard. Get a resale. Thank you, brother.
One of these days.
Absolutely.
We'll work on that. We'll get on that. We'll get this like-
Mr. Ashmore, I'm ready whenever you are, so don't let me hold you up. It's the great Oz. Behind the curtain. It is I.
They're bringing his client up right now, Judge.
Okay, I didn't want him thinking that he had to wait on me.
Thank you, Judge.
You're welcome.
Judge, we're ready whenever you are.
All right, this is cause number CR 21-00304. State versus Matthew Ryan Peters, and we're set for arraignment on the charge of driving while intoxicated, third or more. Go ahead, Mr. Ashmore.
Judge, Mr. Peters and I have had a chance to visit. He has confirmed that his name is spelled correctly, Matthew Ryan Peters, where it appears in the indictment. He and I have gone through the allegations against him, that he understands this is a third-degree felony, that with the enhancements, it's being alleged with a punishment range of 2 to 20 years.
2 to 10. Does he have enhancements alleged in the indictment that increases it to a second degree?
That's my understanding of the way that the state has framed this indictment. And
Okay,
it says in the, I can't screen share it with you, Judge, but it does say in the section under degree, third degree felony, and then in parentheticals, 2 to 20. And then there are allegations below regarding prior offenses regarding alcohol-related driving offenses, as well as a felony offense of credit card abuse of the elderly. And he understands the nature of the allegations against him. The offer at this point is, as I understand it from the state, 15 TDCJ, and that has more to do with the pen pack and the criminal history than it does with the nature of this actual offense. My client has authorized me to enter a plea of not guilty, to work towards a resolution with the state of Texas and explore all possibilities. I believe all discovery has been shared with me at this point. I have some of that information. I'll make sure I have it all, and we'll be ready for our next pretrial setting.
and I'm sorry, you may have said this and I may have missed it. Is his name spelled correctly in the indictment?
It is spelled correct. Matthew Ryan Peters is spelled correctly both times it appears in the indictment. We went through it and he did confirm that.
Okay. All right. The court will find that Mr. Peters has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We'll set this matter for pretrial hearing. And Mr. Ashmore, do you have your calendar available? I'm setting things for pretrial on December 13th and 15th. Do you think that gives you enough time to review the discovery and follow your pretrial motions? Other than that, if you need more time, I could set January 5th.
I've got a trial setting which is likely to not go on the 13th, but I better hold it. I think we can be ready on 15 December, Judge, and I'll go ahead and calendar that.
All right, court sets Mr. Peters for pretrial December 15th, and that'll be at 1:30.
Thank you, Judge.
All right, thank you, gentlemen.
Thanks, Judge. May I be excused?
Yes, sir, you may be.
Okay.
All right, I believe that concludes this afternoon's docket. Thank you, Deputy Everett. Appreciate you.
Sure.
Thanks, Judge. See you at the courthouse soon.
Thank you, Ms. Hadley. You as well.